Ladies and gentlemen, a very warm welcome to you both here at Stanford and to all of those of you who join us via Zoom from Berkeley as well as from Chicago, from Oklahoma, and from places as far away as Austria and Australia, Hungary, Poland, and others, I hope so. It's a great honor for me to have been invited to address you in this lecture series, and I would like to thank Anna for the kind introduction. In my home country in Austria, the story used to make the rounds how the sewing machine was invented by an Austrian called Josef Madersberger, and the typewriter by another Austrian named Peter Mitterhofer. Neither of them managed to market their invention. In both cases, it had been Americans, Isaac Singer and Christopher Sholes, who repeated success only a few years later with improved models. They were rewarded not only with wealth, but also with fame, unlike Madersberger and Mitterhofer, who were virtually unknown outside Austria and also sometimes inside Austria. With Hans Kelsen's situation is different. In Austria, he is arguably at least as well known as Madersberger as Mitterhofer. As a constitutional founding father, he enjoys a reputation which is comparable to Benjamin Franklin, United States. Austria, however, is a small country. No matter how important the role he has played in conception of Austrian constitution, as the federal government emphasized in 1971, that role cannot explain why his works have been translated into more than 30 languages and why it still features in the 21st century in academic conferences in Chicago, in Mexico, Cuba, Beijing, and others. Even in his lifetime, he was a celebrity. In 1934, the then dean of Harvard Law Faculty, Roscoe Pound, even called him the leading jurist of the time. And this popularity ages well and keeps on growing. In 1971, as I said before, when Kelsen still was alive, Austria's federal government created a foundation, you mentioned it, the Hans Kelsen Institute, to tend and develop a scientific legacy. In 2007, a Hans Kelsen Research Center was founded in Germany, which has initiated a complete edition of his works. 2023 saw the inauguration of a project aiming at translating of this edition into Italian. And in 2024, the Centro de Estudios Hans Kelsen was founded in Buenos Aires. Rather than to the Austrian Constitution, Kelsen's worldwide popularity is owed to the legal theory he developed, the so-called pure theory of law, which claims to be applicable not only to the positivist legal order of a particular country, but to any legal order. The theory is less an explanation from where the law is derived, it's often a major source of disappointment for newcomers, than a structural analysis of law and a persistent endeavor to provide a clear distinction between statements about law and political claims on law. Kelsen once illustrated this with the example of a surgeon who must subject his patient to a close examination and can reach for the scalpel only after he's arrived at a diagnosis. All too often, the law is put to improper use to provide a seemingly objective foundation for one's own biased ideas of justice. The one-sided interpretations of force and norms that are, after all, frequently ambivalent. And when a court arrives at a different interpretation of the same norms, this felt to be an act of injustice. Justice was a topic that surprisingly did not seem to occupy young Kelsen a great deal. It was only as he get older that the search for justice became a core concern for him. And the farewell lecture delivered at the University of California in Berkeley in 1952 was entirely devoted to the question on what is justice. The answer he gave to that question was that there's only relative justice, no justice in an absolute sense. What one person considered to be just might appear unjust to another, and the two standpoints were as incompatible as they were equally valuable. It was only if one assumed that God exists, and Kelsen himself was a professed agnostic, that one could lay claim to an objective standpoint from which certain acts could be classed objectively just or objectively unjust. Being left to fend for ourselves, however, we can only put matters we cannot get ourselves to agree onto the vote without any certainty that the result will be perfect. Kelsen's value relativism made him a dyed-in-the-wool advocate for democracy, even though he was keenly aware of the deficiencies and the weak points. 1932, in the eve of Hitler's succession to power, he noted regretfully that it seems to be democracy's tragic fate to have to feed its own worst enemy at its breast. And with the same breath, he warned against defending democracy against its enemies with undemocratic means, least of all with violence. A democracy that tries to assert itself against the will of the majority, even by force, has ceased to be a democracy. Controversial for his teaching in the eyes of his adversaries and repeatedly attacked for anti-Semitic reasons, Kelsen left Vienna and Austria in the fall of 1930 for Cologne, where the then Lord Mayor, Konrad Adenauer, promised him a more congenial environment. 2.5 years later, in April 1933, Kelsen was one of the first professors in Germany to lose his chair for racist reasons. For him, this marked the beginning of a 10-year odyssey that led him from Cologne via Vienna and Geneva to Prague, back to Geneva, then to Harvard and to Berkeley. The language problem was a major stumbling block. Having what was only insufficient command of both French and English, Kelsen tried to retain a chair in the German language university for as long as he could. From the very outset, his brief stay at the German university in Prague triggered tumults of nationalist students, which culminated in a murder plot that was scotched by the police. Hitler's invasion of Czechoslovakia in March 1939 terminated Kelsen's tenure in the same way his tenure at the University of Cologne had been terminated, by mandatory retirement, depriving him of any entitlement to a pension. For 58-year-old Kelsen, this development threatened his very existence. In spring 1933, coincidentally, when Kelsen was forced to flee Germany and find himself a new academic home, the American Academy of Arts and Sciences elected him a foreign honorary member. As both the nomination and vote were anonymous, we know next to nothing about the background. What we do know for sure is that at that stage, Kelsen already had influential admirers in the States, such as Roscoe Pound, who has already been mentioned. While Pound rejected Kelsen's value relativism, he thoroughly agreed with the rigorous separation of is and ought. Sidelining his own faculty, the long-term dean of Harvard Law School submitted a proposal to award Kelsen an honorary doctorate on the occasion of Harvard University's first centenary in 1936. Kelsen's first visit to the United States in the summer of 1936 was a memorable experience. He met people like Felix Frankfurt and delivered a lecture which was broadcast on the radio. Back in Europe, he was again confronted with the Nazis' hatred. He made no secret of the extremely favorable view he took from the United States and cultivated his contacts on the other side of the Atlantic. By the fall of 1938, he actively sought to emigrate to the States and entered into negotiations with the University of Chicago and the University of Illinois, at first unsuccessfully. At that late stage, many vacancies at American universities had already been filled with German-speaking emigres, and the willingness to extend hospitality to newcomers was beginning to wear thin. In the fall of 1999, Harvard hosted a conference that saw Kelsen deliver another lecture, and he used the second visit to the States for the further cultivation of contacts. Caught unaware by the outbreak of World War II, he cut short his stay and returned to Switzerland, and as quickly as he could, the apparent paradoxes accounted for him by the fact that he considered his wife and the two adult daughters who had left behind in Geneva to be in danger from the war. As obtaining visas for all 4 of them was out of the question, the time had now come for the family to split up. Kelsen's elder daughter, Anna, converted to Judaism and emigrated to Palestine. The younger Maria married a man who had an immigration visa to the States. The moment Kelsen knew that his daughters were safe. He proceeded with his wife Grete to embark on the danger-fraught voyage to the States. It was touch and go for the liner they were and to be torpedoed by a German submarine and arrived in New York at 21st of June, 1914. Kelsen had obtained visa for himself and his wife on the basis of a pro forma call from the New School of Social Research in New York, which had already performed the same service to several other scholars in Europe. The truth, however, was that the new school did not have the funds to employ him, nor did he intend to lecture there. Understandably, his thoughts gravitated towards the university that awarded him an honorary doctorate. Therefore, one of the very first things he did after his arrival in the States was to select Harvard. Luck indeed seemed to be on his side. 5 years earlier, in 1935, Oliver Wendell Holmes Jr., one of the most eminent jurists of the United States of his times, had died, leaving the Harvard University substantial funds with which to endow the Oliver Wendell Holmes lectures. It was these funds and additional money from the Rockefeller Foundation, an institution that continued to support Kelsen in the following years, that enabled Harvard to offer Kelsen a one-year visiting professorship. Kelsen hoped it would be possible for him to find more permanent employment at some other university in the course of that year. And with this aim in mind, he entered into negotiations with various universities, particularly with the University of Chicago. In Chicago, he met with strong headwinds. Employing another emigre from Europe was seen not only as an additional financial burden on the university. There were also voices that opposed Kelsen's pure theory of law in principle, even going so far as to accuse it of being complicit in the rise of fascism in Europe. Another German emigre, Waldemar Gurian of the University of Notre Dame in Vienna, Catholic University, wrote to a member of the University of Chicago's faculty, "I believe that Kelsen represents a mentality which is responsible for the terrifying collapse of the European civilization, for the victory of primitive political religions." Negotiations finally petered out, and Kelsen counted himself lucky that he managed to secure enough third-party funds for Harvard to offer him a post for a second year, this time only as a lecturer. However, in Harvard too, Kelsen drew criticism from colleagues. The year he spent there as a visiting professor saw the arrival of a young legal philosopher, Lon L. Fuller, in America's oldest university. Fuller had hardly settled in when he published a book entitled The Law in Quest of Itself, which reviewed some of the legal theories current at the time. He was a special critic of Kelsen's pure theory of law. Its attempt to draw a clear line between the law that is and the law that ought to be invariably ended up in legitimating the law that is, which is tantamount to legitimating those in actual power. This made no difference. No, to Kelsen, who was still hoping to be offered a post at Harvard after these negotiations with Chicago had come to nothing. Feverishly, he penned book after book and article after article in a language he had not yet mastered completely for a readership whose tastes he had not yet gotten the measure of. When the Association of American Law Schools offered him to have his most important books published in German translated into English, he asked them instead for a commission to write a completely new book, A General Theory of Law and State, which was published by Harvard University Press in 1945. In this book, Kelsen attempted to acquaint an American readership with his pure theory of law. Compared with his other books in German, the general theory is much less heavy of theory, citing a wealth of examples from the US Constitution to illustrate its general considerations. The general theory went on to see 4 editions in Kelsen's lifetime and is to this day the most widely distributed of his books. The reactions it drew from American jurists largely ranged from incomprehension to dismissal. The reason has sometimes been cited for this is the occasionally clumsy language. Kelsen had asked a Swedish jurist rather than a native speaker to translate the book, and ominously, he himself had taken a hand in translating parts of it. The core problem, however, was that the pure theory of law itself is inseparably twinned with European, more specifically with German thoughts and German language. Many stable concepts, simply resist the translation. When Kelsen says, for example, the art is the sin of a legal norm, the German word sin may be rendered both as meaning as a sense, and indeed both is meant. Depending on which variant the translator opts for, the result gives the original text an entirely different drift. What the general theory also made clear was that many of its general statements referred to concrete problems of European legal orders. They therefore failed to gain purchase in the United States. However, this may have been the pure theory of law remained, to use the words of Jeremy Tailman, a path not taken. To this day, it's at most a footnote in legal literature in the United States. This takes me back to the two Austrian inventors I mentioned in the beginning, Madersberger and Mitterhofer. Did Hans Kelsen also meet his Isaac Singer and his Christopher Scholes? To a certain extent, this role may be ascribed to the English jurist H.L.A. Hart, who a few years later developed the theory of law that has certain parallels with Kelsen construct. Like Kelsen, Hart was a legal positivist, and again, like Kelsen, he was harshly criticized by Fuller for drawing a clear line between law and morals. In most other respects, this concept, especially as expounded in this book entitled The Concept of Law, diverges completely from the pure theory of law and proved to be much more accessible for an Anglo-American public than the accommodating pure theory of law. This constituted a major difference between the United States and Latin America. Even though Kelsen spoke neither Spanish nor Portuguese, many of his books were translated into these languages and were welcomed enthusiastically. To this day, the pure theory of law is an integral part of many law curricula in Latin America. Back in 1931, Kelsen paid a visit to Cuba. This was followed in 1949 by visits to Brazil, Uruguay, and Argentina. And in 1960, he went to Mexico. In all these countries, he was given a reception that is best described as triumphal. In a 1958 interview, he reminisced about the 5 lectures given in Buenos Aires on the object of legal science to an audience of at least 500 lawyers and students. And he said, if I were to deliver these lectures in the United States, people would probably ask me, what are you talking about? And the answer would be about something we're not particularly interested in. That the pure theory of law failed to catch on in the United States must not, however, be taken to mean that Kelsen himself was a fail in the States. Even the theory's lack of resonance proved the major obstacle to his professional career. Having again obtained third-party funding, he stayed on at Harvard for yet another year. But the Harvard Corporation vetoed in advance the third year, even if Kelsen were to succeed in securing the necessary funds. Committing to a third year would have meant saddling Harvard with a moral obligation to provide long-term employment to Kelsen. So in the academic year 1942-33, 60-year-old Kelsen therefore accepted the offer at the University of California in Berkeley to teach at the political science department. The political science department then, rather than Berkeley Law School, was to become Kelsen's academic habitat for the subsequent 10 years. Some European Kelsen scholars have tried to interpret this as another proof of Kelsen's failure to take root in the States. This, however, is based on a fundamentally misunderstanding. At that stage, Kelsen himself has realized that there was no way he could prosper in typical American law school, where case studies were the be-all and end-all. The concept of political science had a much wider scope in America than in Europe. The political science department offered Kelsen an opportunity to deliver an annual course of elements of jurisprudence, which allowed him to introduce undergraduates to the core tenets of the pure theory of law. Many of these undergraduates would go on to study at law school. His core course in Berkeley was Principles of International Law, which mirrored his chief interest. However, since he had left Vienna, international law had increasingly become one of his chief concerns. In later years, he in fact became one of the leading exponents of international law in the United States. In 1950, he published the first comprehensive exposition of the law of the United Nations, a 920-page compendium, which is still referred to regularly both in the Security Council and the General Assembly. Between 1960 and 1963, Kelsen was the chairman of the American group of the Institut du Droit International, an almost unparalleled achievement in this discipline. The road to this climax was long and tortuous. Kelsen had not been offered a tenured position at Berkeley. Until 1945, he was a mere lecturer with a succession of one-year contracts. This unsatisfactory situation led him to cast around for other opportunities, including jobs in the United States government. That he did not obtain American citizenship until 1945 blocked his particular avenue. It was therefore imperative for him to prove himself employable and useful by, for example, holding war courses at Berkeley on the legal order of Nazi Germany, even though this was far from his core area of interest. Kelsen's hour came when President Roosevelt created the Foreign Economic Administration in 1933, which, among others, employed a great number of emigres from Europe. They were tasked with producing concise outlines of the legal, economic, and social conditions of the states to be liberated. Within the purview of this agency, Kelsen produced memos and outlines of Austria's constitutional situation and analysis of the question of how to deal with Austria after the war. In passing, as it were, he also supplies analysis of the German legal situation. And in 1944 and 45, shortly before and shortly after the German capitulation, he published two major papers in the prestigious American Journal of International Law, in which he advised against concluding a peace treaty with Germany. His advice was for the territory to be administered jointly by the four Allied powers as a condominium. The Allies would then jointly create a completely new German state, which would not be legally linked to Nazi Germany in any way. The 1,000-year Reich was to be treated as extinct. In post-war Germany, these theses were taken to mean that Kelsen propagated Germany's downfall, causing widespread alarm. However, as far as the Allies were concerned, it's important to note that with regard to all crucial issues, they adopted the course Kelsen had recommended. They jointly assumed supreme control of Germany, and having secured this vantage point, they created a new statehood for Germany, with the provision, of course, that they proceeded not to creating not one German state, but two. Any assessment of the extent to which Kelsen exerted direct or indirect influence on this development would require further research. In addition to that, immediately after the end of the war in May 1945, Kelsen was contacted by one of his former PhD students from Europe, who was at that stage working for the US Army Judge Advocate General. The latter's Deputy General John Weyer has established a war crime office in preparation for the trials of Axis power war criminals. At his invitation, Kelsen returned to Washington, and in the summer and fall of 1945, Kelsen produced a series of memoranda on particular problems areas of law. The most important of these memoranda dealt with the problem of retroactive criminal laws. The International Military Tribunal in Nuremberg had been established as part of London Agreement of 8th of August 1945, that is, after the end of the war. Among other things, this agreement defined the criminal charges on which the war criminals were to be tried. Most constitutions comprise provisions that ban the enactment of ex post facto laws. This is also the case with Article 1, Section 9 of the US Constitution. Acting in full accordance with the pure theory of law, Kelsen decided to keep the juristic issue separate from the moralic one. There were in his eyes no juristic problems, as neither the US Constitution nor the Constitution of any other state was relevant for the International Military Tribunal. The latter was an institution under international law, and as far as international laws was concerned, there was no such ban of retroactive laws. However, what about the moral side of the matter? Surely the ban of retroactive laws was justified, as it appears unjust to punish someone for something the culpability of which was unknown to them at the time they committed the act in question. But were Nazi war criminals really entitled to claim in good faith They did not know that murder, robbery, theft, and all the other crimes they had committed in thousands and millions of cases were punishable by law. If, however, the act was at the moment of his performance morally, although not legally wrong, a law attaching ex post facto sanction to the act is retroactive only from a legal, not from a moral point of view. Kelsen stated. Pursuing this line of reasoning, he arrived at the justification of the Nuremberg trials, both in juristic and moral terms. It should be noted, however, that his publications, Kelsen also leveled criticism at the trials, finding fault especially with the fact that it was exclusively the judges of the Allies that presided over trials of war criminals of the Axis powers. However, that may have been, Kelsen had certainly proven his usefulness, and General Weyer intervened in person to make sure that Kelsen was awarded US citizenship as soon as possible. Already in 1944, Kelsen's superior at the political science department at Berkeley, Frank Russell, had already proposed to the president of the university to appoint Kelsen to a chair at long last. Initially, at the beginning of Kelsen's spell as lecturer at Berkeley, Russell had felt, as he put himself, that Kelsen's best years were already behind him. But he confessed to having been proved wrong. Kelsen had published so much in the most prestigious journals and had aroused enthusiastic interest among students who had flocked to his lectures in great numbers than had been the case with his predecessors. At the beginning of the fall term of 45, Kelsen was appointed full professor at the University of California. Kelsen was 64 at that stage, and his tenure as full professor was therefore limited to no more than 7 years. It resulted in an extremely modest pension that he started to draw upon his retirement. Financial worries had dogged him almost all his life. In 1953, he filed a restitution claim in Germany, which led to his rehabilitation, but to only a fraction of the pension from the German state he would have been entitled to. His savings deposited in a German bank account had been pilfered by the Nazis at some stage between 1933 and 1938 and proved impossible to trace after the war. It was only 1960, when he was almost 80, that he was awarded the highly endowed Feltrinelli Prize by Italia's Accademia Nazionale. This freed him from financial worries for the rest of his life. Prior to this, it was arguably financial considerations that made him return to a 1-year teaching post in Geneva after his retirement in Berkeley, and subsequently to accept the post at the Naval War College in Newport, Rhode Island, for the academic year of 1953-54. This job was well paid, but gave him little satisfaction. Apparently, as a matter of routine, the president of Naval War College sent an inquiry to the FBI as to Kelsen's past record. And this led to surprising intense investigation to determine whether Kelsen had ever engaged in anything resembling anti-American activities. 1953 was, after all, the year when the McCarthy era reached fever pitch in the United States. It turned out that back in 1949, the regents of the University of California had asked all staff members to take an oath of loyalty to the US Constitution that dismissed 31 employees who had refused to take that oath. While Kelsen was not one of them, he had voiced criticism of the compulsory aspect of the proceedings to a student paper. And this aroused suspicion among the law enforcement officers. They started to make inquiries into Kelsen's surroundings among his colleagues. What we know about these proceedings we owe to a freedom of information request. Unfortunately, the files of the FBI shared with us are heavily redacted, they are blacked out. And so we have no way of ascertaining who were Kelsen's character witnesses. However, all of them gave Kelsen an excellent report. He was an impeccable Democrat. Not only has personally rejected communism, he had astutely denounced its ideology in several publications. He could, in fact, be called one of the most articulate and best informed advisors of communism. These assessments are based on Kelsen's later works, especially on the political theory of Bolshevism, which was published in 1948. That Kelsen had been sympathetic to the Soviet system in the first years after the October Revolution and had called it 1920, a most genuine democracy was not mentioned by the FBI. Just fortunate for Kelsen. There's no doubt that his take on the Soviet Union has changed over the years, as the Soviet Union itself had in turn undergone changes in. In the political theory of Bolshevism, Kelsen concluded the Soviet Union, rather than being a dictatorship of the proletariat, was in fact the dictatorship of the Communist Party, and declared himself unable to spot any relieving features in that system. In his time in Europe, Kelsen had laid down his views on democracy in a great number of publications. In 1954, he held a 5-day guest course at the University of Chicago, the Walgreen Lectures, on the topic of foundations of democracy. The redacted version of these lectures, which was published 1 year later, is his most comprehensive disquisition on the theory of democracy. It's all the more amazing that it's virtually unknown to this day. It is, on the one hand, a critic of several theoreticians of democracy and work at the time, such as John Hallowell, Friedrich Hayek, and above all, the former student of Kelsen, Eric Voegelin, now a fellow exile in the United States. On the other hand, it's a summation of everything Kelsen himself had to say on the topic on democracy in the past 35 years. In 1920, he had been buoyed by optimism, but his introductory words in 1955 were tinged with a much darker mood. So he said the 19th century had seen democracy as an ideal worth fighting for. And after World War I, we were briefly the impression that it achieved a breakthrough. The 20th century, however, had seen democracy in decline. The ink of the peace document of Versailles was not yet dry when in Italy the fascist government came into power, Kelsen noted. In the late 1920s and early 1930s, Kelsen had raised his voice to warn of the rise of fascism. Now in 1955, as the world kept on spinning, he called Soviet communism even more dangerous than fascism or National Socialism, because it claimed to represent a full-blown democracy. He made it clear that not everything that laid claim to being a democracy deserved that appellation. Democracy necessarily always and everywhere serves the ideal of political freedom. Ladies and gentlemen, this lecture will be incomplete if I did not mention Kelsen's wife, Margarete Grete, at last briefly. The two had married in 1912 and remained together for more than 60 years. Given the wealth of the bride's family, Kelsen knew from the outset that he had married well. But it took him a while to realize that in Grete had also found a partner who had badly needed intellectually. Social conventions being what they were at the time, Grete had never studied. But in at least one case, it had been shown that he translated into German foreign language article that had been published in Kelsen's journal. There's a good deal of evidence that she was far more than a housewife and mother. In his old age, she became indispensable for him. And when Grete died in January 1973, he survived her only a few weeks, and Kelsen died in April 1973 in the nursing home in Orinda in the county of Contra Costa. Thank you very much.
So much. So I have a few questions, mostly biographical. So first off, I think I've read this before. Am I right to assume that Kelsen was Jewish?
It was Jewish, yeah, of course. Jewish in the sense of Nazi terminology.
His wife was Gentile. She converted in order to be part of going to Palestine. How long did she stay in Palestine?
About 10 or 20 years. So let me explain. He is of Jewish origin. So for Nazis, he's Jewish. And his father was Freemason. For himself, we are not quite sure. Family thinks he was not, but he was agnostic all the time. For reasons of career, he was baptized twice. First Catholic, evidence as also as a Catholic country, and then second Protestant Lutheran church. Maybe because there was a ban of divorce for Catholic people in Austria at that time. And he changed from Catholic church to Protestant church in the moment when they married. And his wife changed from Judaism to Protestant religion at the same time. So there were practical reasons, not the religion one.
So then a different question, still biographical. So when he went, who did he contact? I have got personal reasons for instance. When he went to Chicago, who did he contact? Did he contact Morgenthau?
Morgenthau was late.
Yeah.
Morgenthau was late on. There was the Waldman lectures. Was Morgenthau was behind. It was especially Charles Merriam, the political scientist who was in Europe before in the 30s, and there he met Kelsen, and they were close friends.
I want to ask about the pure theory of law in the Nuremberg trials. So with legal positivism, didn't you were saying that he was drawing a distinction between morality and law. So law is based on what statutes and so on are passed by legislature. So how did he? Can you go into a little more detail about how he felt about the Nuremberg trials and this distinction between morality and positive law? Because the idea of positivism is that the law is what is created, not that there isn't a kind of Kantian deontological sense of law.
Yeah. So separation between law and morality was crucial for Kelsen. Always he emphasized the independence of both norm systems. So the norms of morality are also a norm system of its own, but independent, and they must be, because it cannot be. You cannot criticize a legal order as unmoral or unjust if you connect them. So they have to be distinguished for criticism. And the question where the law comes from, that's the I mentioned, it's a very difficult one. Kelsen explained with the basic norm. That you have to think this legal order is valid, and this an act of thinking, not an act of positive law, but this thinking act is called the basic norm, and that all the legal norms comes from that, and not from any moral, because there are so many morals. There's not only one moral order, but every culture has its own think of morality. And the core question is that we all always mix this, and then the question is just a part of analysis. We say retroactive laws are forbidden, and it's clear because they are unfair. And this thinking that's unfair is so fixed in our consciousness that we don't have any chance to reason why are they forbidden. And so when we separate the legal question from the moral question, it becomes clear it's only a technique. It's in legal means there is no ban of retroactive laws in international law, but only in national law. And so the legal question, simple, is no, there's no ban. It can be done. And separated from them, you have to ask the moral question. And then you have to ask, who is moral? Who is moral? Are the Nazis really on the moral, the good side? Have they done well when they committed murder, when they have committed robbery? So that cannot be true. But in fact, the Nazis, all the accused people like Göring and Hess and so on, this unjust with retroactive laws. And there was a twist who is in the moral side, and that cannot be done. That cannot be just. And so I think Kelsen, by analyzing them, then dividing them, made the proof that it's okay to punish them.
Could you talk a bit more about his concept of democracy in the Waldman lectures and how this was influenced by his commitment to positivism?
Yeah, theory of democracy has undergone several changes. Early Kelsen was strongly influenced by Rousseau and also by Lenin. You can see the first big book, the of democracy was written 1920. So in the same year when the Austrian Constitution came into force, and very soon after the October Revolution, and he had some sympathies to the especially to the Soviet system, the council system. The council system, when everything is voted, there's no separation of powers. All is combined with people who are voted, and there were no professionals, no officers, but layman who does everything. And see, that's the original idea of democracy in it. But as soon as 1920 said, in theory, it's a good idea. In practice, it cannot work. And later on, he saw Lenin himself went back and gave power back to the officers because he saw the Soviet system does not work. So this early situation he was in. He was strongly proponent for a proportional voting system because he said the parliament has to be a mirror of the people. The parliament has to represent most of the different meanings. And he also developed some concepts of voting systems that never came in force, neither Austria nor any other countries. Later on, this changed. Something changed with practical experiences. For example, theory of division of separation of powers. He said, of course, yes, it's not democratic, but after all, it's a good thing for controlling everybody. This changes, and of course, all these scripts are also the answers to several problems. So 1920, he dealt in detail with communism. 1925, 29, he dealt with fascism, of course. With fascism and also the cooperative system. We had in Austria the rise of, some say it's fascism, some say it's not, but they have a cooperative system. They say, don't the parliament of parties, but the parliament of experts. The expert has to be, and Kelsen said that makes no sense. To be a farmer does not mean that I have to vote always in the courier of the farmers of my lifetime. And later on, in 1955, he goes back to communism. But of course, Stalin is the kind of Stalin, so it changed. But the main starting point for everything was the value relativism for everybody. That he said nobody of us knows about the truth, and so if nobody knows about the truth, we have to make a vote.
I'll ask a question that doesn't really have anything to do with legal theories. I'm not a legal scholar, and maybe it's just was a side remark in your presentation, but you started out by presenting a few Austrian scientists or inventors whose
The beginning of Witzberger, yeah? The inventors, Mitterhofer and Marsberger, yeah?
So the reason why I asked that question is that the question I'm going to ask is that I'm originally from Belgium, I'm from Flanders, and there a lot of people have the same idea that like, oh, we developed one of us developed this theory, somebody else ran away with it, the Big Bang theory, or some perceived accomplishments like the purchase of Manhattan or something like that. And the Dutch get all the credit for a lot of things that are happening in Belgium, if they are good or perceived to be good. So what explains in the case of Austria that this happens to these Austrian scientists? So is there, I don't know, an economic reason for it, or a cultural reason, or is it just in the minds of Austrians that they don't get this credit, just like in Belgium?
Well, but I think Austrians have a tendency to overestimate their own efforts. And as I think invention of a sewing machine or invention of the car of the automobile is not a task of one single person, but of many persons. Huh? What will be a car without pneumatic wheels? Huh? There was also an inventor of the car in Austria, Siegfried Marcus, but this car didn't have any brakes. Huh? So can we be the inventor of the car? No. Same is true also with Kelsen. Kelsen is often said the founder of constitutional justice. In fact, there are many people who dealt with this topic, and Kelsen had some great ideas, but he was not the only one. And I think this high problematic. I have to confess that the two names, Marsberg and Madover, are from my mother. It's just a story the mother tells the children. A simple story how good we are. Reality is much more difficult, I think. So if the French fries come from Belgium or from United States, are also a difficult question.
Yeah, we have a question from the online audience. Sure. The question is how is the relationship between Kelsen and Israeli academia after 1948?
Israeli.
Mm-hmm.
Yeah. Kelsen never been in Israel. He was not a Zionist. He had very fears for his daughter, who gave birth to a son just in 1948, a very dangerous time. But he was invited in Israel to give. There were several attempts, invitation to guest lectures, and sometimes also by the Israeli government. And he tried to ask, but it did not come nothing out because nobody could for the funds. He did not get any funds to get out to Israel.
He gave the Austrian lectures. Another giver was Richard Robert Bell. This is democracy. It goes to the
Walgrim lectures, yeah.
So it raises the question: how much thought or interest did Kelsen show in American democracy in the period in the United States, which would go from the New Deal years down to Brownlee Board and its implications for which we're still dealing with today. Or was he much interested in American politics? But so, or for that matter, in the American founding, especially this night, or was he indifferent?
Astonishingly, Kelsen wrote very few about democracy in the United States. The Walgrim lectures were the only example, and that was very comprehensive. But he didn't intervene with American politics. He was sometimes asked by an Austrian emigre to encourage with some emigre circles, and he thought, I don't think so. It's also he doesn't want to take part in such movements. The Walgrim lectures were introduced by, I mentioned him, Eric Voegelin. Eric Voegelin was an assistant of Kelsen in Vienna, and later on theoretician of what I said before, the Austrian fascist state. He was not a Nazi, but an Austrian fascist, and had to flee from the Nazis to America. And they had his own ideas, and he also gave Walgrim lectures, I think 2 or 3 years before Kelsen, and there he talked about some ideas that the socialism and also fascism would be a kind of a secular religion. Kelsen was against that. That the religion has to be with a transcendental God, and socialism and ideology, but no religion. So big parts of Kelsen lecture, Walgrim lectures, are the answer to Voegelin's lecture.
Did he have? We often think about Vienna between 1900 and the outbreak of the war in 1914 as, birthplace of modern ideas and Wittgenstein and so on. Was there any relationship between logical positivism and the philosophical trends in Vienna at the time and his idea of the pure theory of law? And also, how did he end up, especially seeing Professor Rocco here, how did he end up being the father of the Constitution? That's in your title there. Why did they turn to him, or why did he have such an influence on the Austrian Constitution? That's before the date of your talk, but.
So, the first, the question to logical empirism and the Vienna circle of Moritz von Schlicken and so on. There were very few connections. Very few connections. It's astonishing because the real positivists like Schlick say there is only and is, there cannot be a separate art. Everything has to be positivist, has to be a being. They said Kelsen is a kind of metaphysics. So the worst thing due to Kelsen. So there are only little connections. He knew some of them. And very late, there was a movement, the unity of science. The idea that all the different kind of sciences form a unity. And there's there were some meetings, some meetings, and the one I mentioned was a meeting in Harvard in 1939, was a unity in science meeting where Kelsen also delivered a lecture. And there he was fantastic. He thought about society and nature, between the is of the nature and the society, with anthropological and legal historian studies, and there was a big deal for him. The other one, would be part of another lecture, maybe in April or so, how he did become the constitutional father. I prefer the word of an architect who's building a house for the devices of his chief. He was in close contact. He was in close contact in the last days of the monarchy with the last prime ministers of the monarchy, as well as the first governors of Austrian Republic, especially Karl Renner, the first state chancellor of Austria. And it was the personal wish of Karl Renner to entrust him to draft the constitution. Kelsen did so, and not only that, he also accompanied the way of the constitution by passing the Constitutional Assembly all the time, so with several conferences and meetings and so on. So he really had a big influence of the structure of the constitution, and also of course with some core questions. For example, the constitutional justice, of course. But this is very would take. In fact, we have now a very big third-party fund research project in Freiburg and in Vienna, just for this question, for the emerge of the genesis of the Austrian Federal Constitution.
I wanted to ask you if you could expand a little bit on Kelsen's time in Berkeley and what his relationship was with the university. If he found like an academic home here.
That's not so easy to answer. Some people say he was isolated, and of course, I said political science department. He himself understood this fact and said, "My pure theory is better in the political science department than the law school." But in fact, he was disappointed. There was not one PhD student who wrote his dissertation with him, because he only taught to undergraduates. He had a close friend, Armin Ehrenzweig. Ehrenzweig was an Austrian lawyer, about 10 or 20 years younger than Kelsen, who was professor at law school, and invited Kelsen every year for a guest lecturer in the framework of his own course. And Kelsen and then Ehrenzweig also arranged birthday parties for him, and also a meeting with H.L. Hart. There was a famous meeting of Hart, discussion meeting with Kelsen and Hart in the 60s. So there were his close contacts. Anyway, there is still one person alive who knew Kelsen. His name is Richard Buchsbaum, original from German descendants, but living in America since the Second World War. He's not about 90 years old now, and is professor of commercial law. So it's not a close scientific contact, academic contact, but he did know Kelsen very well. Still alive and still in faculty, and then some weeks ago I've seen him there.
Well, in that case, our heartfelt thanks for a wonderful lecture, and thank you very much.
Thank you.